Hello, I'm Cara from 1-800-RESPECT and welcome to today's webinar entitled Access to Justice for Migrant and Refugee Women Impacted by Violence, the Experiences, Barriers and National Framework to Improve Accessibility to Australian Courts. Thank you for joining us. Our webinar today is being presented on the traditional lands of the Kulin Nation and we wish to acknowledge them as traditional owners. We would also like to pay our respects to their elders, past and present, and the elders from other communities who may be present today. 1-800-RESPECT is a confidential information, counselling and support service that is available 24 hours every day of the year to support people impacted by sexual assault, domestic or family violence and abuse. People can access the service by phoning 1-800-737-732 or visiting 1800respect.org.au. Today's 1-800-RESPECT webinar will discuss some key issues impacting on access to justice for migrant and refugee women, including barriers to reporting family violence, communication barriers, and barriers to full participation in the court process. The webinar will also provide some strategies to improve access to justice for migrant and refugee women impacted by violence, as outlined in the JCCD National Framework for Improving Accessibility to Australian Courts for Aboriginal and Torres Strait Islander women and migrant and refugee women. Please note that this webinar is live and interactive, and we will try to answer as many of your questions at the end of the presentation as possible. We are now pleased to welcome our presenters, Maria Dimopoulos, Managing Director at Myriad International Consulting Services. Maria will outline the work of the Judicial Council on Cultural Diversity in improving access to justice for migrant and refugee women. She will discuss the national consultations that took place in 2015 and key findings in the report entitled The Path to Justice, Migrant and Refugee Women's Experience of the Courts. Our second presenter today is Magistrate Anne Goldsbrough of the Magistrates Court of Victoria. Magistrate Goldsbrough will speak about the objectives and proposed actions of the National Framework to improve accessibility to Australian courts for Aboriginal and Torres Strait Islander women and migrant and refugee women, produced by the Judicial Council on Cultural Diversity in 2016. A warm welcome to you both. It is now my pleasure to hand over to Maria to start the presentation.
Thank you very much, Karen. Thank you to everybody who has tuned in to hear of this important work. If I too, as a migrant to this country, can begin by acknowledging that we've had 80,000 plus years of wisdom and knowledge, much of which has been drawn on in the formulation of a lot of the research and findings in this document. Let me start by giving you a bit of a context to the work that was done. Australia, as we know, is now considered by organisations like the OECD as one of the most ethnically, culturally, religiously and linguistically diverse countries in the world. That's a remarkable situation to find ourselves in. Some of the stats, of course, are that nearly 7 million Australians were born overseas, that 5 million people speak a language other than English at home, and of course the issue of English proficiency or limitations around English language proficiency, over 600,000 that have limited or no proficiency at all. And 300 languages are spoken in Australian households. Indeed, I understand from recent stats that over 50 new languages have been introduced in the last 3 years alone. Now, we benefit enormously from such diversity, but of course it presents so many challenges, particularly for those who are newly arrived, either as skilled migrants or refugee and humanitarian entrants. The establishment of the body called the Judicial Council on Cultural Diversity, I certainly viewed as being one of the most significant in relation to addressing issues of access to justice. Established in 2014, primarily in response to the growing concern by judicial officers across the country for the kinds of barriers that were presenting for marginalised communities, many of those refugee and newly arrived, and so concerned about issues of procedural fairness, equality in terms of the treatment of all court users, and the need to promote trust and confidence of the Australian courts. The JCCD was actually set up under Council of Chief Justices. Now, this in itself is really quite significant because it suggests that the highest level, really, the council being the combination or including all the heads of each of the jurisdictions, state and federal. So it gives you some idea of the significance of the JCCD. So we expected that any research that was going to be undertaken would be taken on in a fairly significant way. So really, what happened was that the the Office for Women decided that they would fund this project, which included a series of consultations. Now again, as someone who's worked in this field for a fairly long time, the opportunity to take up the support of the JCCD as part of the process of consultations was very important from our perspective. So we held focus groups with women from a range of ethnic, cultural and religious backgrounds, and we recognised that this wasn't going to be easy, that the process itself around the consultations would need to be part of a partnership arrangement with migrant and settlement organisations, and the opportunity really to build some trust with many of the women who were quite nervous or fearful of speaking to us. So putting in place a range of considerations and ensuring that any follow-up that needed to happen did in fact happen. Part of the consultations also involved consulting with stakeholders from key legal services, from migration services, and of course peak domestic violence services. The wisdom that they had established over many years of working with these women was viewed as being absolutely vital to informing our knowledge around what the issues and barriers might be. As I say, the key questions really informing the inquiry were around women's qualitative experiences of the courts, looking at what the barriers were from their perspective, what some of the outcomes were, and most importantly, to move away from what a lot of the research previously had done, which was to focus on the problems, on the barriers. This time we really wanted to get the thoughts and ideas around what would have improved access to justice for these women. The findings, of course, and I really want to encourage people to go to the JCCD website and have a look at the report because I think it's well worth a read. Obviously, we're not going to go into the level of detail that the report does, but the path to justice, migrant refugee women's experiences of the courts, documented the range of views and opinions that have been expressed both by women themselves, grassroots organisations, and the range of stakeholder groups that were involved in the discussions. The consultations identified some major barriers that refugee and migrant women face when they reach court, but of course there are also findings that suggest that even before they get there, there are a number of significant barriers that prevent women from seeing legal recourse as an option at all. Some of the barriers, of course, are specific to migrant refugee women, and we'll address some of those in a moment. But of course, what we find is so many of them are common to women across cultural and ethnic groups who might be experiencing family violence. So whilst the outcomes might be particular to this group or cohort, we'd like to see that the response to it, and certainly the improvements that have been identified, would apply to every woman and children experiencing family and domestic violence. Let's have a look at what some of these pre-court barriers are, and many of you out there working with women and children would know many of these, but it's worth just touching on some of the key ones. Now, we know that often information about women's legal rights is done in English, or it's often in writing. For many women from diverse linguistic backgrounds, where literacy itself may be an issue, accessing written information can be a problem. Indeed, as someone who was heavily involved in the consultations, I recall one of the Bari South Sudanese women saying, well, what do we do when our language is not written at all, when there is no written language? This insistence on developing information strategies about our legal rights in writing just doesn't apply. So the knowledge that we gained, of course, was that we needed to look beyond written forms of information, even when they are translated. And of course, the concepts are not always equivalent or well known to these women. The very idea of rights in certain jurisdictions was something that women said was completely unknown and unfamiliar to them. The lack of financial independence, and of course for some of the women who were totally dependent, perhaps by virtue of being on spousal visas, was something that we repeatedly heard. Issues, of course, of financial abuse, where women were prevented from being able to access any financial resources. In fact, for some women, being denied basic financial resources to the point where they couldn't feed their children. The need for integrated support services, of course, particularly for newly arrived and refugee women, where part of their experience also involved questions of migration status, questions around their visas, the need to be able to go to almost a one-stop shop to get information about the full range of legal issues that were presenting was something that came up. On top of that, of course, the need for housing, concerns about, well, what would happen if I decided to pursue legal options and leave my relationship? This clearly caused further trauma for many of the women that were looking at the range of options presented. When we say poor police responses, I think it's also fair to say that for many of the women, particularly those from refugee backgrounds, that the pre-arrival experiences of trauma, and at times where some of the women said that the very perpetrators of the violence in refugee camps were the people that were allocated to their protection, including police officers, that this meant that the perceptions of policing and police in Australia was, of course, going to be profoundly affected by those pre-arrival experiences. We also know, and UNHCR, or the United Nations High Commission for Refugees, tell us that for services in Australia, we need to be cognizant of the fact that almost 2/3 of women and children arriving in Australia have been sexually assaulted on more than one occasion. This is even before they get here. A lot of community pressure, and women talked about the significance of having high-profile community members coming to convince them that they needed to withdraw applications for protection orders, needed to consider how they were bringing, and I quote, shame to their community by virtue of taking legal action. This is incredibly powerful. As women said, it's not just a matter of leaving my husband. In many ways, I'm leaving the entire community. The prospect of being isolated from my language supports, from my family supports, this is undoubtedly going to play a significant deterrent in trying to pursue some of the options that were being presented to them. We spoke of the uncertainty about immigration status and, of course, the fear of deportation, even when we knew that threat to report was one that was baseless. For these women, often unaware of their rights in Australia, the threat of deportation of themselves or their children was very real. And finally, the costs that we know can be quite prohibitive. The cost of engagement with the legal system can be quite significant. So, language, of course, no need to reiterate this one too strongly. I'm sure many of you working with women who experience language barriers would know this. But communication is a significant barrier for many of these women. The lack of interpreters in accredited accredited interpreters in many of the languages. And of course, even when interpreters were made available, that they were often in a situation where their knowledge of the law and legal processes was extremely limited. In one or two instances, women reported that sadly interpreters had crossed the mark, so to speak, and had taken it upon themselves to offer moral advice, suggesting women return back to their husbands. These were situations where, sadly, the legal practitioner, being unaware of what was taking place, didn't understand why all of a sudden the nervousness around proceeding with the case started to really set in. So clearly we need to appreciate how and when interpreters should be engaged, and of course the importance of reporting situations where interpreters may be in a situation where they're influencing women to either withdraw or suspend the legal process that they've engaged with. The legal system is complex at the best of times, and what I certainly came away with after having heard so many countless stories of women reporting on their lack of understanding of what was taking place, of often being met with scenarios in court where a Bible was being presented and they were Muslim, not understanding what was being told to them even through the interpreting process, nodding prolifically in the hope that they would appear to be compliant when in fact they didn't understand what they were saying yes to, and on it went. So the issues were certainly considerable barriers in so many ways. The importance, I think, too, of understanding safety issues, that for some women in courts, and we know that the courts have become increasingly aware of situations where safety might be an issue. In some courts, indeed, alternative entries have been made available. I know, and Magistrate Goldsbrough no doubt will talk about this, that efforts have been made to ensure that there are different times where the perpetrator might, the alleged perpetrator might appear and so on. So I know that these safety issues have been addressed in many, many ways, but for some of these women, they weren't even aware of how they might make the request. So they were often in situations where family members would approach them, intimidating them, calling on them to withdraw their applications and so on. In one situation, a woman said to us that it only took one look from his family, and I knew that my family back home were now at risk. It was enough to make me, and I quote, pick up my bag and leave. And that's exactly what she did. Concerns around the attitudes and actions of judicial officers, many of which we acknowledge were inadvertent, many based on a lack of understanding of what the situation of a refugee or migrant woman might entail. An example that one woman cited, indeed I think reinforced by her support worker, was where a situation involving diaspora woman who spoke of the fact that the magistrate said, well, if he's not in the country anymore, he certainly doesn't pose a risk to you. Not understanding how threats made to her family back home were indeed profoundly affecting her confidence around proceeding with the case. So I want to say really that we could go on, and the examples that were presented in the report, I think, say a lot about what areas of improvement are required. Can I say, however, that the response by the JCCD has been incredibly inspiring. It, in many ways, for someone who's been involved in legal reform, represents an important opportunity where not only was the willingness to listen to the voices of women and children themselves, but then to act on it, to act on them in ways that means that we can make the sort of changes that can dramatically improve confidence, can dramatically improve our capacity as those working in the sector to be able to say with a degree of confidence ourselves that access to justice isn't fiction, access to justice isn't fantasy, access to justice is certainly within the reach of migrant and refugee women. Magistrate Anne Goldsbrough, if I could just take a moment to say, has been a partner, true partner for those of us working at the grassroots level. While certainly she and I have refound each other as members of the JCCD, I think, Anne, it would be fair to say that 20 years ago we were working on models of court reform as part of a mock court strategy where we invited women from the communities to come in and visit courtrooms, get the opportunity to really engage with magistrates, and that was the beginning of a journey, I think, around change.
Well, thank you, Maria. What an introduction. Anne Goldsbrough is my name, and thank you to all of you for attending today through the webinar. And I acknowledge also the traditional owners of the land on which I'm sitting today, recording and speaking to you all from Melbourne. I have been fortunate enough to be an inaugural member of the Judicial Council of Cultural Diversity, and really picking up on what Maria has said, there are many people in courts and judiciary who feel very strongly about access to justice, and the opportunity to have the Judicial Council pick that up and provide the form and the work for it is very welcome indeed. I'm going to go through some brief slides with you in relation to a framework. So the Judicial Council of Cultural Diversity has auspiced the work that Maria has spoken about and seen it as critical work. And from that, of course, that council now wishes to have a framework to show how courts and all of us can implement them in our own jurisdictions. So this applies federally and each state. So we drew on those findings, as you can see, and there are two reports. The other one, in fact, is for Aboriginal and Torres Strait Islander women, and I hope there'll be another webinar on that specific report. You'll find much is the same, but of course there are relative and important differences that you'll have an opportunity to look at later. So it is an aspirational set of principles, there's no doubt, and practice guidelines. Importantly, this framework has been endorsed by the Council of Chief Justices that Maria spoke about. So this is a group of those in charge of courts in their state and federally, including on that Council of Chief Justices is a representative of the High Court, of course, our Chief Justice. So let me talk to you a little bit about what the framework does. So it sets out the values and principles of how we should strive to meet the matters raised and identified and now evidenced through these reports. When we talk about courts, the most important feature for me is about equal justice and access to justice for all. And it is regardless of race, sex, religion, language, faith, or ethnic origin, of course. And it means, particularly here, that culturally diverse women are able to, I hope, understand and access the legal process. It seems to me if we make the court system open and provide access to justice, then every single person, no matter where they come from or what their understanding is, will have that opportunity. Courts and judicial officers and our staff, of course, need to be free from unconscious bias and discrimination, and have cultural awareness or cultural competencies and the understanding of gendered inequality. And this framework simply outlines some of the ways that we can ensure that the principles we all aspire to, I don't know anybody who doesn't, actually, in the justice system, want to make the right decision in difficult circumstances. So this framework is to help us do those things. You'll see on the screen there, on the slides, fairness, impartiality, independence, competence, integrity, transparency and accessibility, timeliness and certainty are, of course, all words that we use about our justice system and about our institutions. So the national framework outlines 7 action areas, we call it, based on the core values and court activities in the International Framework of Court Excellence, another important document. And again, if you head to the website, you'll see, for the JCCD, you'll see links to these. Court leadership and management and planning and policies, resources, proceedings and processes all sound quite dry statements, but they are in fact integral in relation to access to justice. The national framework's proposed actions are also grouped into 3 main categories: community engagement and public information, logistics, support and judicial education. And these are matters which I'll discuss a little further with you. So, excuse me while I shuffle a paper, and I apologise for that. So, under court leadership and management, of course, it's essential that we have, in demonstrating a court's commitment to provide equal justice and equal access, and through that process, some of these community engagement and public information processes, in my view, are an important way to proceed. So, in my view, and Maria's mentioned it, engagement with the community is an integral part of ensuring that our courts are understood and that access to them is open. Judicial officers, in my view, should engage with the community where appropriate in order to build trust and understanding, and some courts and tribunals are already well underway. Through the JCCD, there is a group and a community group, and each court, in fact, now has a representative on the community arrangement, community organisation processes. Courts should consider holding open days and tours that are open to services, and you'll find many courts across Australia do that already. There's law weeks and so on, but there are other ways that we can engage community. Judicial officers and court staff should consider becoming involved in community education forums for women from migrant and refugee backgrounds on specific areas and court processes. For example, my court, Magistrates Court in Victoria, has a walk in her shoes tour where all people can come and see how an application for an intervention order would proceed through the court system to inform them. In many years gone by at the family court, we also had information sessions there, and I had been a member of that court before being a magistrate, and those open forums where people could come and ask questions, in my view, informed and ensured that people had access to the appropriate processes of the court. It strengthens relationships, and it demonstrates to, of course, people outside the court, and here particularly women from culturally diverse backgrounds, that the courts are an accessible institution that would potentially alleviate some of the intimidation and stresses that women would have when going to court by being able to attend, understand the layout, understand where they could be, and how to engage with court staff. Judicial officers and court staff are likely also to learn from the experiences of others, and I must say, through my nearly 22 years as a magistrate, that has been something I've done every time I speak to a community forum. Every time I speak to judicial officers engaged in their education about family violence, I learn something new, and it helps form my views. I think courts should also hold regular meetings for court users and various forums, and most courts, certainly Magistrates Court in Victoria regularly does that, and I know others do also. In relation to resources and relevant issues for migrant and refugee women, there is much in the community that is translated, but of course that's also an assumption that everybody can read, and we shouldn't do so. The educational videos on court processes in the context of family violence would be important development, and our court forms and brochures are being developed hopefully across Australia in plainer English. You'll see on the Judicial Council's website that we now have some wonderful fact sheets which have just been produced, and I'm going to indicate them to you because they've been an important development. such as assessing the need for an interpreter. Now, I will show you what they look like, but these are fact sheets which you'll all have access to, and there's been some wonderful videos developed for education. Unless we truly can understand or walk in a person's shoes as to how it might be attending our court, then it is very difficult for us to be ensuring that our processes are at least open. We are a court and there are rules and obligations, and none of that should change, and it won't. But we do need to make sure that people understand the process as best they can, and that we are responsible for ensuring that they do so. So, proposed actions for the courts and tribunals through this framework proposals includes reviewing layout of court and security measures and signage to improve safety, encouraging on-site legal services, and many do already have duty lawyer services, and separate waiting areas for women attending court for family violence matters. Now, this original review, as Maria has outlined, started about access to justice, and when we looked at the way that migrant and refugee women and Aboriginal and Torres Strait Islander women were accessing courts, it really did most commonly seem to be through family violence or family breakdown matters, which is why we concentrated on this area. That's the reason for this particular focus of these reports. So many courts are undertaking this work for separate waiting areas already. For example, in Victoria, through the Family Violence Royal Commission, there are 5 sites that are being additionally developed to what we had. I know also in Southport in Queensland, they've got separate waiting areas. I was up there talking with judicial officers on family violence matters only on Tuesday this week, and they are also developing their family violence specialist courts. The court that I sit in at Moorabbin is a specialist court already, but we are certainly welcoming the enhancement offered through the proposals and recommendations of the Family Violence Royal Commission to make it even better. One of our recommendations, and this was one of my strong ones having been involved in the development of this work, was the engagement of cultural court liaison officers at court. That isn't to suggest there'd be one for each culture. It's simply an acknowledgement that those who have this particular position, that is from a culturally diverse background, may be assisted by understanding the court processes with particular attention to their needs. I also think recruiting staff from diverse backgrounds will be an advantage for the court, and certainly this is part of the framework. Establishing a cultural diversity committee, many courts have done this. Courts often now have many committees, but it's very important that we share our views and ensure that frameworks such as this are implemented. We do need to collect data, that's always important, and one of the other recommendations, which is a strong one arising from our family violence work, is in fact about daily coordination meetings in family-related matters, and that ensures that the court staff and those attending court will understand any particular difficulties or challenges for a family. It's important then to know that interpreters have been engaged, and if not, then arrangements can be made. Judicial education is a popular topic in the community, and what I'd like to say, being involved in some of this for a very long period of time, is that there is a significant amount of judicial education and support, professional development going on, as there is for every other member of the community. It's important to acknowledge, I think, that judicial officers are everyday people who have everyday lives, but a particular job to do. And frankly, I think it's a wonderful job and a wonderful opportunity. To do that, it is, in my view, part of our obligation to ensure that we are updated, aware, as informed as we can be about the lives before us, of which we're then required to make judgment. So, ongoing support and training for judicial officers and registry and court staff, because we're not just the judiciary alone, we are surrounded by important and integral people who run a court, about cultural awareness, I'd call it also cultural competency, core family violence training and jurisdiction-specific family violence training. That is ongoing. As I've said, I was in Queensland on Monday night and Tuesday speaking to Queensland magistrates in our National Judicial College ongoing training across Australia. Victoria, for example, has had many days and ongoing days with respect to education for judicial officers with respect to family violence. speaking at another conference in June, where we've got County Court, Federal Court, Supreme Court and Magistrates again attending further training. These are ongoing, and judicial officers and courts take this very seriously, and this framework certainly endorses that. For all of us, trauma-informed practice and working with interpreters are now also important developments of understanding the work that we're doing, and this framework outlines that, and for that I think it's extremely important, and I commend all courts to it. In summary, excuse me, the framework is focused on adapting court policies and procedures, resources, with the aim of improving access to justice, obviously, and equality before the law for women from culturally and linguistically diverse backgrounds. And it is, as I've said a couple of times, or particularly in the context of family violence and family breakdown, that means in federal courts, state courts, all courts, and tribunals. So enabling the cultural considerations for diverse court users doesn't, of course, provide an advantage. Rather, it provides an assurance to all people in Australia to receive equal justice and have equal access to justice. It is important that there is an open and transparent, if you like, playing field. I don't usually use sporting analogies, but it's important that we provide an opportunity for everybody to give their best evidence before the court, and that we have a sound and settled processes for hearing that evidence. I'm content to take questions, which I understand will come through, Maria and I. I'm happy to answer any more questions on the things that I've raised. Thank you. There are some questions. Thank you. I had to work out where they are. My apologies. How can you contact me for community education? Well, I do have to sit in court every day as well, but of course you can also contact Maria, and there are ways that we will be undertaking that work. I'd suggest contacting the Judicial Council. I'll also, you can make contact with the court generally in relation to community education, but contact the Judicial Council. What can frontline workers do to improve their awareness of the law and legal processes concerning family and sexual violence? That's something that I feel very strongly about, probably unsurprisingly, because working through development of specialised family violence responses in the state, as I have over the many years that I've been a judicial officer, what's apparent to me is that we now have wonderful recommendations through the Family Violence Royal Commission, through the Australian Law Reform Commission. I was a commissioner back in 2010 for the Family Violence and Family Law Inquiry. In those reports are recommendations for the development of significant social supports for any person experiencing or engaged in perpetrating family violence. Let's be clear about that. That means that we have a lot of people in the community who are now engaged in this work. I think the challenge even for those people is to understand the legal principles and the rules on which must apply in every state. Every state has family violence legislation, protective legislation. And understanding the difference between crime and family violence protective legislation is critical. A lot of people don't want a person charged with a criminal offence or findings to be made. There's a range of reasons we now know, and I now know in the work I've been engaged in, and that is fear or really just wanting a perpetrator to change their behaviour. And I'm using the language of this particular forum rather than when I would be in court. So most women who have appeared before me in thousands and thousands of intervention order applications over the years really just want the behaviour to stop. What that means is that the social supports in all areas, including on the telephone or engagement in the community, need to also understand the legal process. That was a long way of explaining where I was getting to. However, I think that the court should also provide that access and openness to information. I would encourage all workers in the field to attend a court, attend a walk in the shoes tour, or come and sit and watch court. Familiarise yourself. Attend a court as if you were applying. Understand what the process is. Gather the information sheets many of us hand out at the counters about the process. Be careful not to give what might amount to legal advice if you don't have that experience. It is my observation, sadly, that occasionally that line is well overstepped and it creates some difficulties. This is a complex area. There is no one right answer to what we do about family violence. There are a lot of answers and a lot of work to be done, and all of us working together from every side of the bench, if you like, is what we need to do. So inform yourselves. There are other questions in relation to legal advice. In fact, they're moving so quickly. I feel like John Fane when he says he can't go through them. So, which ones would you like me to deal with? Further barriers for regional courts. That is accurate, and we know through the recommendations of the Family Violence Royal Commission in Victoria, for example, from where I'm speaking and have the most knowledge, that we are doing what we can to separate parties. The reality is a court is a court, so we need the best processes now to separate parties. That probably comes from understanding that a person who's been brought to court as an alleged perpetrator of family violence by a respondent in an intervention order or an accused on a charge does not want to be there. This might be the first time the behaviour has been called out. So if we can provide opportunities for people to understand the process, come to court early, make contact with the court and say they're going to be concerned, what's going to happen. They can make arrangements to arrive early, perhaps wait in another area closer to the counter. They can bring friends with them. Do not engage with a person in the court precincts. You can breach an intervention order in a courtroom and in a court surroundings, and we well know that. So the court has, in Victoria, and I know other courts, are taking this very seriously. I work with a lot of courts across Australia, and am fortunate to have opportunities to speak to their judicial officers, and I know that we are taking it seriously. It is a work in progress, and we need to work together on that. I don't know the representation of culturally diverse judges in Australian courts, but you know what? We're all culturally diverse. My family's very long-standing Australian-born one side and English the other, so most of us have that mix, but I don't know any specifics if you had something in mind. Questions about cultural liaison officers and a role. Of course, this is a work in progress, and because we've made a recommendation in this report, that would be a matter for how each court would develop it. I just gave you some ideas of what I thought would work, and that is if there's a person, doesn't matter if they're, shall we say, strongly Australian born as the cultural liaison officer, that means that person is designated with a role to take care of those issues. That's all. I think I'm very interested and entrenched in this area, and you've already heard my background. That's not particularly complex culturally. So I just need to read some of the questions. There's very long ones, I'm sorry, that I'm trying to read through about particular circumstances. It wouldn't be possible to respond to particular circumstances, but perhaps what I'll do is summarise that many of you may have experience and tough experiences and feeling like a court or the court system is impenetrable. Making contact with one of your local legal services, making contact with Victoria Legal Aid, making contact with your court and seeing what information you can gather about the process is going to be a very good start. Again, make contact with somebody at a police station for that person. See if you can understand what the processes are. Most police stations, and I'm sorry again speaking about Victoria, have a family violence liaison police officer, for example, who's charged with the responsibility of some oversight. Gather the information, ask the question, is the best support you can provide. There are some suggestions about projects of volunteers who could facilitate many of these recommendations. Could the JCD arrange training programs? I can't speak for them. The idea is a very good idea. About any, shall I call them professional volunteer organisations such as Network or other court support programs that exist, there still need to be some fundamental rules and principles, and yes, making sure that people are informed about how to do this is an excellent idea. Volunteers are an important part of our community. I agree with that. I can respond to them by email. Goodness, how many are there? Do my best. I'll do my best if they're sent to the JCCD. I'll do absolutely my best to respond to them.
Can I add, perhaps, just to say that whilst the framework is incredibly important in terms of improving access to justice, it's obviously a partnership. And I think one of the things that certainly emerged in the findings around the consultations was the need for legal practitioners, for community legal workers, certainly for frontline workers, to become more culturally competent, or to at least look at some of that background information that's so important in terms of knowing the kind of information that's going to be useful and the way in which that information needs to be presented. There is an awful lot of people, women who come from what we call law avoidance societies, where for many of these people, the intervention of law would be a totally unfamiliar event, that in many ways their experiences of problem-solving processes have been primarily non-legal prior to arriving in Australia. Many are stunned indeed by the level of legal intervention on a daily basis that they have living in Australia. So it's important to understand the points that Her Honour was making about the distinctions between criminal and civil law. These are often not understood. The assumptions that workers make about some of the fundamentals that perhaps we know living in Australia, and then wonder why there's enormous confusion around some of that. The translation of information and recognising that there are no conceptual equivalents for certain concepts, and that be wary when you are working with an interpreter as a frontline worker yourself or as a legal practitioner. Try and use plain English. I mean, there's a skill to how you engage with interpreters as part of that process. I recall one woman saying that the interpreter literally translated execute a warrant as execution. Now, for that woman coming from a background where that was sadly an all too regular reality, she was immediately deterred from pursuing it, believing that the outcome would be the execution of her partner. So I think it's important for us to recognise that this can only work. The framework for the judiciary is such a fundamental part of reform, but it can only work in partnership within a holistic, systemic approach to these matters. So I'm really hoping that what we've demonstrated today, Your Honour, is to say that it's only as part of that dialogue, and the JCCD as part of its membership is certainly predominantly judicial officers, but inclusive of community representation like myself, like Munya Andrews, who's the Aboriginal Torres Strait Islander legal practitioner who sits on the council, that's when real change happens, when we have these dialogue opportunities, when we work closely together, when we recognise that each of us has obligations around making the system work. We can't keep saying it's a problem of the legal system. The legal system, particularly via judicial intervention, is stepping up and saying we are going to take this stuff on, but we can only do it in partnership.
Absolutely, Maria, and thank you for outlining that. For me, the Judicial Council has provided absolute position and clarity about what's required, and has given judicial officers worried or concerned about some of these issues, an absolute foundation to move forward, as Maria has said, and it is about a partnership and understanding what we can do in working with the community. I did want to respond here to a couple of the questions about interpreters that Maria had raised and others have questioned. What's being done to ensure interpreters are providing correct and non-biased information? Well, that is the question, isn't it, when I don't understand what's being said. Importantly, another substantial piece of work by the Judicial Council, these are our two main pieces of, I think, significant work, the interpreter standards for Australian courts. This is a substantial document. I mentioned to you already the fact sheets about assessing the need for an interpreter, but through that document, and it's an area I feel very strongly about and have spoken to others regularly on the issue, is about the standards, about the obligation of an interpreter, about them being, in effect, an officer of the court, ensuring that what is interpreted is done in a way that is understood, that judicial officers understand and staff and lawyers understand how best to work with an interpreter in relation to their very challenging work at court. What do we do in relation to the provision of information? How do we make sure interpreters understand the complexity of the matters before them? For example, I'll ensure now that they have a copy of the intervention order summary of evidence with them so that they can read it as well as ensure that it's understood. In a criminal matter, I'll ensure that the summary is also given to them to read in court. These are small things I can do on a daily basis to ensure that the quality of interpretation is there. I have had others say in court that an interpreter has alarmingly told a woman to withdraw, which is how I knew about it. An interpreter has alarmingly told a woman to withdraw, which is how I knew about that. These are difficult circumstances, and that particular framework and these fact sheets and some videos that are going to be available for judicial officers and court staff are a critical development. So that's what we've done. In relation to the courts and open days, there was some questions about a woman's confidentiality. Perhaps I'll be clear about that. What an open day in a community forum would be is us explaining how one applies, for example, for an intervention order, how an interpreter might be engaged, what happens with a criminal matter. It would never go into a person's particular case. I can't and won't comment on a particular case. I only deal with matters before me, but I can talk in generalities and what happens in a broad sense. So a person can attend. They don't have to say who they are. They'll give their name to somebody at the counter, but personal circumstances would never be discussed. I'm wondering if we're getting to the time when we need to sum up. Now, I think we can certainly hear from the JCCD if there are other questions that we can answer. It is intended that we try to answer them, and we'll do what we can. Thank you.
Thank you, Magistrate Goldsbrough and Maria, for a really interesting presentation today. Thanks to Stephanie and the Judicial Council on Cultural Diversity for their support in organising today. We have another webinar happening in conjunction with the JCCD on the 14th of June, and we encourage you all to log into that. It will focus on improving access to justice for Aboriginal and Torres Strait Islander women. You'll receive an email to register for that one in the next day or so. Today's webinar will be available on the 1-800-RESPECT YouTube channel shortly, and a case study will be on the 1-800-RESPECT website soon too. You'll receive a notification when that goes live, and feel free to share it with anyone you think might find it interesting. And thanks to everyone for tuning in today.